Thank you for coming today to the IM Roundtable preparation for Phase 6. So we appreciate you coming in person, and hopefully you'll stay afterwards for a bit of a reception and speak with some of the colleagues. So my name is Andrew Kayiira, Managing Partner of Eden Point Partners and Strategic Consultant to ISDA. Excited about today's panel, and I just want to introduce who we'll be speaking with. So to my far left, I have Amy Caruso, Head of Collateral Initiatives at ISDA, Doug Donahue, Partner at Linklaters, Tara Kruse, Global Head of Infrastructure, Data, and Non-Cleared Margin. And to my right, I have Ed Corral, Managing Director, Global Head of Collateral Strategy at JPMorgan, John Pucciarelli, Head of Regulatory and Industry Strategy at Acadia, and then Ted Leveroni, Senior Principal at BNY Mellon Markets. So maybe to kick us off with the discussion, Tara, maybe we could talk a little bit about the large amount of counterparties that came into scope in Phase 5 and even a larger proportion that we expect for Phase 6. From ISDA's perspective, I know there's been some stats out there. Maybe you could share a few of those with us.
Yeah, sure. Do we have that slide? Yeah. So we did a study back in 2018 to try to estimate the number of counterparties and relationships that would come into scope for, at that point, all that was Phase 5. That data was integral to our advocacy with the authorities to, eventually get that split into Phase 5 and 6. This data, surprisingly to me, seems to have held up fairly well in terms of the divide. And once they broke out Phase 5 and 6, we kind of redid the numbers to check and see what that meant for Phase 5 and 6. The bottom of the slide, you can see what we determined looked like the breakdown for those who probably wouldn't exceed IM thresholds in the near term. I really think that part of the conversation has moved along in terms of the parties that will be able to monitor initial margin instead of having to exchange in the beginning of it. But, John, I'm curious in terms of Phase, 5, right? What did you guys see in terms of sort of actual stats for, overall scope of counterparties, and as well as kind of the divide between monitoring and not?
Yeah. Well, first off, I just want to thank ISDA again for hosting this, and thanks everybody for coming. Hopefully, you find it interesting and informative. I do think that the stats that we saw were pretty close to those numbers. From our vantage point for Phase 5, we saw about 330 firms or so. Out of those, we had about 310 active clients who were part of our services. I think, when we look at the sheer numbers of CSAs, like we saw somewhere around 2,200 Reg IM CSAs, and out of that 310 or so, 180 were moving, were not moving margin, but they were moving threshold. So they were using threshold monitoring because they were below that 50 billion threshold. So that was quite interesting. That was kind of in line with what we saw. I mean, in terms of Phase 6, we're still seeing somewhere around those numbers. I think we're seeing somewhere around like 650 to 800. And I think, generally speaking, it'll be similar in terms of, who's going to move margin. But there is going to be a tail, and I think we'll all kind of talk about it from our own perspectives in terms of what that tail is in Phase 6. But I think how we're seeing it is kind of a third, firms who are going to move margin day one for Phase 6, firms who are going to, I would say, actively threshold monitor, and then there's going to be a tail of firms who, probably won't move margin. They'll be above the 8 billion ANA, but they'll be way below the $50 million IM threshold, where they don't have to get, operationally ready to move margin. So, all in all, those are the numbers that Acadia is seeing. They're very similar to what ISDA put out, and I think when we look at Phase 5, the threshold monitoring was a very interesting piece of it, and we at first thought that the dealers, like the way we kind of set up our services, we kind of put the onus on the dealers to kind of bring Phase 5 along and help them calculate and have them have a lighter touch to Phase 5 firms. But we did see a lot more Phase 5 firms than we thought being really active in terms of putting CRIF through, looking at their agreement setup, and then actively managing their counterparty setup against their dealers. So we're going to see probably a lot more of that in Phase 6 as we move forward.
Just maybe a quick follow-up to that. Do you know why that move might have happened in terms of what you saw from clients kind of shifting away from not so much reliance on the dealers themselves?
I think they probably wanted just more autonomy over their own numbers. They wanted their own accurate view of what their threshold should be, agreeing with their counterparties what the threshold should be, right? And then also, calculating their own exposure instead of just, using their dealer numbers. So there was a mix. I would say that wasn't the majority, but because of Phase 6 and how that's going to split, we're going to assume that there's going to be a lot more of those firms who are going to want to do it on their own and not use the dealer number. But we'll see.
Yeah. Thank you for that.
Yep.
Any other thoughts from the panel on that?
Maybe Andrew, I could just chip in with some market color just based on talking to some dealer clients. It's actually pretty surprising, the numbers that I've been hearing. And this is from specifically from 4 large dealers, all Phase 1 dealers, just to give you a sense of size. They all expect to have over 1,000 clients in Phase 6 above the ANA threshold, but only around 40% of those who they need to document with. The other thing and that was remarkably consistent across that group of 4. The other thing that I would say is more than one of them out of that 4, and 3 of them basically, have told us that threshold monitoring, well, they think it's a very important tool. They're a bit concerned about it because they've had people go beyond the threshold monitoring that they didn't expect to pretty quickly after the September 1 date. So, the 400 number that I'm hearing might be a reflection of people who they think could even be close. They're going to bucket into, I want to document this person because I don't want to have this issue again, where I need to tell someone potentially that I can't trade with them anymore because I thought they would stay below the 50 million.
Okay. So Tara, maybe I could ask you a quick question on the regulatory front. Do you think there's anything that we might want to note real quick?
Maybe a question. Are there Phase 6 firms in the room who are subject to the EU margin requirements?
There is a prize at the door.
No, I'm actually very happy for you because you don't have to deal, So we won't get into the update on the initial margin model validation document because I think you're lucky enough to escape that because that's going to, be less than we would like it to be. So no, I think, let's move on because I think we got a lot of other topics.
Sure. And maybe in the same vein, and we could bring Ted and Ed into this, but Doug, maybe you could kick us off on the documentation front. You mentioned that. So what are you seeing in terms of Phase 5, prior phases, and kind of what you might expect for Phase 6?
Yeah, so maybe picking up on something John said, which is the buy side getting more interested and more aggressive is not the right word, but active maybe is the right word. Assertive. I like that one. We've actually seen, which is different than any other year, we've seen lots of buy-side entities actually come to us and say, hey, I need to get started. What do I do to get started? And that happened basically between, I would say, September 15th and October 1st. We had all of a sudden a bunch of people who we spoke to in previous phases, and they basically told us, hey, no, I'm not going to be in scope. We don't need to worry about it this year. They came to us and said, all right, we need help, right? We're going to either have funds or potentially SMAs, which is a big, big problem, above the $8 billion number. Or we trade a whole lot of security-based swaps, and there is no ANA threshold for security-based swaps. It's only the $50 million contractual threshold. So what do I need to do? So I think that's been the big change this year. We can also talk a bit, and I'm going to hand to maybe Ted and Ed real quick, but we could come back if people are interested to talk about the SEC and those rules and how everything has come into play and sort of how that has further muddied the waters potentially. And there's not going to be a uniform, just a teaser, there's not going to be a uniform approach there, I don't think. Some people will rely on substitute compliance. Some people will do many different things there. So it's just going to ramp up the complexity, I think, for Phase 6 at a time where we're also ramping up volume. So that's not a great combination.
All right, sure. So, yeah, Doug, it's interesting. I agree with you. And what we found, and I don't want to, badmouth any clients, but what we found before the COVID delay, clients were saying, yep, we're going to get ready. We're going to get ready. We're not going to delay. After the COVID delay, we went to our clients and we said, you're still going to work at the same pace as you were planning on, and now you have an extra year. Isn't this great? Are you going to use it? And some of our clients did, and they ended up having a really, really good summer. They were set up well in advance, and it worked out nicely. But a lot of the clients who told us they would didn't. And they didn't take advantage of that time, and there was a mad rush at the end. But to your point, Doug, this time around, we're being rushed by the Phase 6 clients. There's a number of firms, as we are, and we'll talk a little bit later about some of the changes we're making to better the process. But as we're finalizing those changes to better the process for Phase 6, we've got clients knocking on the door. Can you give us the ACAs now? Can you start setting us up? When can we test? All of those things. So this phase is going to be interesting in that they are more assertive, aggressive, whatever you want to say. Probably because of lessons learned. They've just read about it so much. They've heard the good press, the bad press, all of that. And so I definitely have seen that. And then one thing about monitoring, I've heard a lot of different stories from a lot of different clients and a lot of different approaches, and I can talk later about kind of our breakdown for Phase 5. But there was one thing that I just wanted to share, and I wonder if this happened to anyone or this would apply to anybody in the room. But I was talking to a client, and they said they're going to get set up. They're not going to monitor because internally, their internal risk won't allow them to trade unless they are already set up, papered, and have an account open. And that's going to be a Phase 6 firm, which I haven't seen their trade book, but I'm going to assume that they probably could go a while before they breach the $50 million threshold. But their internal risk won't allow them to that. Now, I don't know if that's going to be widespread. I encourage anybody who's on the buy side here, if they feel one way or the other, they know their position one way or the other, to please tell us, because it's good to know if this is an anomaly or if this is something that's going to be common. But that, I think, that potentially could skew the numbers of a third.
Are they going to struggle, though, to get their dealers to prioritize them if the dealers don't have the same perspective on their trajectory?
Yeah, that definitely that is the case.
And I'd almost jump in right on that point, because I think that's such a great observation of what happened in Phase 5. So I'm from JPMorgan, as we said. JPMorgan has a big derivatives trading side, obviously largely trading with everyone out there. And what I'm driving at is kind of the mismatch that was happening in the industry. When we would talk to our clients about getting ready for Phase 5, they're like, we're gung-ho, we want to get done, tell us what the deadlines are, we're going to meet them. We talk to our dealer side, or any dealer, but I'll use our internal dealer side. We're gung-ho, we want to get it done, we don't understand why the clients. And everyone was talking past each other, right? Everybody seemed to be individually motivated to get everything done in advance, on time, whatever. And the reality was just the opposite. Right. And I think when you think about the industry as a whole, and Ted said it, we had a 1 year, COVID reprieve, right, that the industry, for the most part, let's face it, frittered away. Right. I don't think we'll ever see another delay for any regulation that the regulators don't want to delay for their own reasons. They're not going to delay it because the industry asked, because they're going to mean that that's not going to amount to anything in the end. So I think I say it all as a cautionary tale for Phase 6. That I do see the same that Ted said. I think there is some amount of the prospective in-scope clients that are getting motivated and are starting a bit earlier, but it's certainly not 400 names or 1,000 names, right? It's some subset, like anything, right? Maybe 20% are doing the right thing already, but 80% I'm worried about. And I know I can speak for Ted. None of us, I think I speak for the old, none of us want to go through what we went through in Phase 5 again in Phase 6, right? So we're going to talk about some ideas we have later on about how hopefully the likes of Ted and I can help prevent that from happening again.
Appreciate that. I was gonna turn to Amy maybe and say, on that point of preparedness, I know there's quite a bit that's been done on the industry front. So maybe you could tell us a little bit of what the working groups are working on and looking at, and kind of lessons learned, so to speak.
Sure. Thank you, Andrew. And it's not humorous, because that would be insensitive to say, but we do have a custodian working group, a Phase 6 working group. We have the WGMR oversight, which is mainly Phase 1 through Phase 5 dealers. And they're like all talk bad about each other, but yet when they get together, everything's all fine and dandy. So it's like, okay, let's get it together, let's work together, let's get moving. But we do have a lot of work from phase 1 through 4 firms helped prepare for phase 5. And now there's some twists and turns because phase 6 is going to be a little different. We have more asset managers who are managing separately managed accounts, as Doug had said, and that adds a twist. You have situations where you have end clients who don't have any interest in doing what they've said their asset managers are meant to do, but yet the asset managers can't do what they need to do with documentation and onboarding without powers of attorney and all these details. So how do we help firms kind of whittle away what they need? And we do have, we call it the ISDA Margin Info Hub, and it is a fantastic, I'm just quoting people who have emailed me that it's fantastic. I'm not saying it is because we built it, but it's a fantastic resource that has checklists and user guides and compliance charts on different jurisdictional components, because of course not all the jurisdictions are the same when it comes to eligible collateral or ANA calculations. So all of our working groups have developed these materials, but most recently our custodian collateral working group, which Ed and Ted are on, we just produced a new video that's out about calling Connecting to Custodians, quite catchy for derivatives talk. But we have 3 custodian representatives going through the KYC process, which is the biggest hurdle that you're going to have to tackle first with your both receiving and pledging counterparties. Our phase 6 working group, we call that our newcomers. So that's just for any firm that is in phase 6, and we're really focusing on FAQs and getting them up to speed, and then also trying to pull out some nuances. And we do get some, I was going to use a creative word, but it's a mild swear, so I won't. So some interesting questions that are very specific around UCITS or AIFs or commingled funds. So we're trying to dig in there. And then we have our very large group, our margin and collateral processing, where everyone is invited, vendors, infrastructure providers, dealers, buy-side firms. And really there we're looking at a life cycle event chart that we developed a few years ago and digging into some unique experiences that phase 6 firms are saying, okay, well, wait a minute, what do I have that is a legacy trade, and what can or I can't do to get into not avoid initial margin, but just make sure I don't go there until I absolutely have to. Because as you mentioned, some firms kind of jumped in, and we've been told that that's because of traders' lack of training. So they didn't know what the initial margin impact was going to be. And then initial margin threshold monitoring. I think that's going to be kind of the big catchphrase for phase 5. And Tara and I just spent the afternoon working on we haven't decided what we're calling it, a reference guide. Sounds too bold, but some helpful tips around initial margin threshold monitoring. And then there's the ISDA SIM governance group, which I skipped that, so you can do that one.
Yeah. So if anyone is planning to or interested in using the ISDA SIM for your IM calculation, we have the SIM Governance Forum has been running robustly for several years now, and meets every week. And anybody who is interested in using the model and wants to find out more, you're welcome to come. We have some pretty intense conversations, but there's a lot of useful information as well. So certainly, reach out or go to our website and sign up if you are a firm who is expects to be subject to regulatory margin requirements and may want to use SIM.
So maybe it's a good time to pause there and see if anyone from the audience has any questions based off of what they've heard. This is meant to be interactive, so please don't hesitate, or comments that you've seen that others might welcome from phase 5 experience. Sure.
Oh, yes. I was like, I know Suzanne's going to have a question, but I didn't realize it was going to be for me. Yes?
In the very helpful guides that are on the ISDA website, and you've mentioned the one about jurisdictions, does that include information about who needs to comply with the regs? So in the U.S., the dealers need to comply with the regs, not their counterparties, whereas in the EU, there's a, sort of there's a combined obligation, for both parties. Does that
I don't think.
Not in the ones that are on the Margin Info Hub. We do have a set of comparison charts on the broader rule sets that we share with members. So if you don't have those, drop me a line and I'll send them to you.
We have free stuff and we have non-free stuff. But most of it is free.
Anyone else?
I'm seeing many disparities emerging because of the difference between the prudential rule and the CFTC rule, by ignoring the SEC security-based swap rule for the moment. But my understanding of the way you would count AANA for prudential purposes is rather different from the CFTC rules, particularly given the way that they revised them earlier this year and all the good work MRAC did. But when I search for the evidence of MRAP's good work in the prudential rule set, I don't see the same result.
It's not there. Yes, so you're right. So we were successful in getting the CFTC to align with the BCBS IOSCO framework and other jurisdictions in terms of having the ANA calculation, March, April, May. But the U.S. prudential authorities have not been so inclined, despite engagement with them, to align. And so you do have this odd situation where the ANA calculation period for Phase 6 for the U.S. prudential regulatory authorities has already passed, right? So if you haven't done that calc, get it done. But, and then it comes up, next year for the rest of the jurisdictions and the USPR. So there's a chance you could get a different result, right? Which I think is going to be awkward and difficult. We already know it's possible to get a different result based on the different currencies and thresholds for the different jurisdictions. So it's kind of a mess, and that was part of the rationale that we had used to get the CFTC to agree to align globally. But so far, the U.S. prudential authorities have declined. They've indicated that they don't think it's going to be so disruptive or problematic. I guess we'll kind of see what happens. I do think it creates unnecessary complexity, and it would be a lot better if they were aligned.
Tara, they're still the only one, the only outlier that still has the May through.
For the ANACAL period, yes. Yeah. You also have this inconsistency around the compliance date post Phase 6, right? There's inconsistency. So in terms of after Phase 6 ANA calculations and the opportunity that somebody might fall out of scope or come back into scope, you have the U.S. prudential authorities, the EU and the Swiss, and I guess the UK, since they're based on the EU, that are rolling on the calendar year as opposed to September 1st. So that's going to be another hassle, right? And the other area where the CFTC did align globally.
And ISDA has all that information, right? Is that on?
Yeah, that's one of those magic charts on the Info Hub where, we do lay out, because it gets confusing, what the ANACAL periods are for different jurisdictions, when the compliance dates fall, and also what the methods are, right? So the other area where the CFTC aligned was to go to the month-end averaging as opposed to the daily averaging that the USPRs have.
Maybe the other thing I would mention, the biggest difference we see in practice between the CFTC and the prudential rules is the U.S. person definition. And that's going to be really relevant for Phase 6, right? Because the U.S. person definition in the prudential regulators rules basically looks at place of formation. For the CFTC's rules, it looks at place of formation, but also looks at principal place of business. And for an asset manager, that could be where, the asset management company is, not where your fund is established. So that has come up a lot. Maybe just, similar to that is substitute compliance. So, and this is a CFTC SEC point, and this happens to be a pretty hot topic at the moment with a bunch of clients. So for the CFTC, there is subcomp with the European rules. And as you may remember or may not remember, there was the subcomp came out, and then Chairman Giancarlo made some statements right after, basically saying, we expect people to be treated the same under the CFTC rules and the EU rules. And what the entire industry took that to mean is if you're an NFC minus under the EU rules, and you can avail yourselves of that substitute compliance, you don't have to exchange margin, at least not regulatory margin. The SEC's subcomp is very, very specific and basically says if you don't have an exemption under our rules, and they give the actual section references, then you have to collect. You can collect in the manner specified under the EU rules or the UK EMIR, but you have to collect. There is no NFC minus out. So that's hitting SPVs and small managers in the EU.
Thank you, Tara. Doug. Sure. Any other points before we move on from the audience? Okay, feel free to continue to chime in because we want it to be interactive. So maybe this is starting out with Ted. In terms of some of the challenges that you were referencing before in phase 5 and kind of some of the things that I think Ed mentioned and you guys might be tag teaming on to try to help clients. Maybe you could avail us of some of those challenges and kind of things that are being done now to help firms move forward.
Sure. So, I mean, the challenges all stem from volume, right? I mean, if we only had 5 clients to onboard, 10 CSAs, it would have been fine. But the challenge it was stemmed from the volumes, and it stemmed from the deadlines and how much time we had to bring those volumes through the pipes. And we'd set deadlines, and some of the clients met them, some of the clients didn't. But even with the clients, even the body of clients that met them, they met them right at the deadline. So we had a lot of just kind of trickle of documents coming in, trickle of contracts and ACAs, and then boom, February and March, we got hit very hard. And then we were scrambling to get everything done. And fortunately, the story ended nicely, and it was a success. But as Ed mentioned, it was a painful process. So some of the challenges or some of the stress points that volume created, just negotiating the documents. Now, we in phase 5 went with a non-negotiable ACA with elections, so you could customize the ACA between you and your counterparties to the liking of your counterparties, but the main document was non-negotiable. One of the challenges was clients didn't believe that, and so we did a lot of discussing and educating and bringing things in. And I know my colleagues felt that pain as well, having to explain to them, no, I know you're an important client, but we can't change it for you because change it for everybody. So I can't imagine for any service provider that had a negotiable document, how they would be able to handle that volume. I mean, it would have taken, significant legal time, significant business time to support that. And by the way, side note, the clients that struggled against it the most later thanked us and said we could have never done this without because of the volumes, without the non-negotiable docs. So that was good, but there's negotiation time for all the docs, because some docs, like the custody docs, the security docs, and all of that, it's time consuming. And there's only just so many hours in the day and so many lawyers on your payroll that you can handle that. Receiver setup was a huge challenge. So realize that for all the dealers went tri-party, and you had a huge number of now buy-side coming in who have never dealt with tri-party before, and they had to get set up in the tri-party model. Unlike third-party, which first of all, everybody has experience with, but also the receiver doesn't have to do much after they've agreed to the margin call. In tri-party, the entire flow depends on receiver connectivity, and receivers also accessing the system and telling us what they agree to the exposure, what the exposure number is, and this caused it. This created a couple of issues. Right, one is you have to get all the receivers set up, and you need an infrastructure to be put in place, and you have to educate them and give them SWIFT specs and all of that. And so just the blocking and tackling of getting people set up was a challenge, and it's going to be a significantly larger challenge just because of the numbers for phase 6. But one of the biggest challenges was the receivers didn't even know us. They never thought to reach out to us. Now, we asked our clients to please tell your receivers to reach out to us. We'll get them set up. We have an email box set up. We had a lot of documentation we could give them to help them along the way. But honestly, it's not for the dealers. The dealers had a lot to deal with getting ready themselves. So I'm not sure that telling all of their clients to go talk to BNY Mellon to start getting set up as a receiver was on the top of their list. And we reminded people, but it's as much on us for people coming late as it is on our clients. And so ultimately there was a mad scramble to get all the receivers set up in time to be able to actually receive collateral in a tri-party environment. So that was obviously a huge challenge. I think those were the two biggest challenges. The rest are just typical operational capacity challenges. Understanding and planning for how many people you're going to need to get all of this through a pipe when you don't really know how many accounts are going to have to be open by September 1st, right? We got our numbers. We went out to our clients, received the pairings list. Those pairings lists changed over time through no fault of the parties. A number of reasons why a firm might say, no, I'm going to be in scope. I'm going to be out of scope. Dealer 1, don't set me up. I'm going to concentrate on dealer 2 and 3 first. So these numbers were always changing, and we have so many hands that touched, are part of the onboarding process to capacity plan for that when you don't know the total number that's coming and you don't know when that number is coming in is very difficult. And so I'd say those were probably the 3 biggest challenges.
Yep. Yeah, no, thank you. I not much to add to that. That covered that obviously very well. I would say, when looking ahead more than looking back, right, here in the U.S., right, if you want tri-party, you have 2 choices. Make a choice. Choose Ted, choose B. Make that choice early, right? And just make not only your own lives easier, make the whole industry's life easier. The sooner that choice is known, whether it's tri-party, third-party, full outsourcing, collateral management, the whole process starts moving along, right? You're thinking back to phase 5, we saw people delay that decision to, even April, May, kind of thing. It's like, you just can't let that happen, right? I mean,
so if I could just jump in,
Yeah.
and I know there's nuances here, but just why do you think people are delaying that decision?
Yeah, and I wouldn't say it was it wasn't the big numbers, right? But I think some clients I think either hoped that they'd end up, their true ANA calculation would be below threshold and they would fall out, one possibility. 2, something we didn't talk about yet, but became a big thing in phase 5 is forbearance, right? I mean, we referenced it, but the fact that you aren't going to exceed your thresholds for quite some time, so you wanted a document, but you didn't have to complete the whole process, right? Prior to probably a year ago, I don't think I'd ever heard of forbearance, or certainly not as in relation to Seg IM, right? And then all of a sudden, we're talking about it left, right, and center. And there's nothing wrong with that. And when we look ahead to phase 6, and as John said, if it's 1/3, 1/3, 1/3, or whatever the breakdown is, that last tail, will most likely be in that forbearance category, right? And that's fine, right? But don't use that as a reason not to get everything done. Right? There's no penalty in getting everything done early, right? So not even early, on time, just get it done. And then it's one thing less you have to worry about. And then I think Andrew made reference to it, like all of a sudden, for whatever reason, your trading volume may crank up, right? The traders have a mind of their own, right? So they may end up seeing something in the market and all of a sudden you bump it up against threshold when you didn't think you would for 3 months and you're not ready to go. And nobody wants to go on the DNT list, right? So that, what seemed to be, at least in some part of the population, a willingness to forestall things, right?
And there seems to be just so much work to be done, and it's sure everyone in the audience could attest to, depending on your point of view at coming at this. So, John, maybe turning it over to you. Quite a bit that Acadia does. You mentioned some of what you do for clients, but what are you seeing out there in terms of where you think that the clients are most coming and saying, this is where I need support, and it's maybe different than what you've seen in the other phases?
Well, I think just to pick up on Ted and Ed's comments, and I think where we're going and what we've all been saying for quite a while is, there is going to be a natural bottleneck no matter how you slice it. And I think, the work that Boney and JP are doing to incentivize or to make sure that the word gets out to ease the bottleneck is obviously something that we have to do. We're doing that at Acadia as well. I think we're just really in the beginning phases of like assessing even though we have the numbers, like assessing the flavors of buy side that are coming into phase 6. There's going to be more, managed funds that have, several asset managers that are going to need to, manage their threshold monitoring, which could be a challenge if you don't have a centralized view of all of that and you don't have the principal looking at, at all their different relationships. But, the help with calculating SIM is another thing. It's just as simple as, am I going to go grid? Am I going to go SIM? We had, I could probably share a little bit of some feedback we had with one of our major dealers, U.S. dealers, that they're seeing, they're seeing some initial Phase 6 firms actually going to grid because it's just for their portfolios or that particular client, it's just more beneficial. So, there's going to be a mix. I think Phase 6 is going to throw at us a lot of different flavors of what we've already seen in Phase 5 as far as challenges. Obviously, the numbers are bigger. We probably have to get done earlier than we did in Phase 5. But I think we also have to be more nimble in terms of how are we going to, approach them and know exactly what they're going to need. There's ANA calculation services, there's clients and collateral management services that are doing that. So there's all these different aspects of that. And there's also the pre-trade. People are looking at pre-trade analysis. How can I stay, not to Amy's point, what she said, not to avoid IM, but, how do I maximize and optimize, how I'm trading? I think even though they're going to be somewhat smaller clients in terms of size, they're just going to have different types of challenges that we're going to have to deal with that maybe we haven't seen yet.
Okay.
Yeah.
So, Andrew, jump in,
please.
This conversation, I think, is a really good one. And just to cap off, right? Ed said, make your decisions and make them fast. And I just want to say that again, that is really important. Don't issue RFPs and try to figure out, hire a consultant and figure out who has the best tri-party model, right? Talk to Ed, talk to me, see who you like better, and pick them. And if it's going to be
depend
third
on the
party,
time of day with the two of them.
if it's going to be third party, talk to Ed, talk to me, talk to our friends at State Street Northern Trust, a couple others, and then pick the one and move forward. And the same, John, you just ran through all the other things you need to do. There's ANA calculation services, there's SIM calculation services, there's admin services. This is not normal times, right? Nobody has the time, and the clients don't have the time, if they don't realize it, you don't have the time to do a really methodical, long-term comprehensive search with RFPs and roadshows, all of that kind of stuff. There just isn't that kind of time, and you're not going to get the attention from the service providers that you would in any other day. But in 2021 to 2022, that just isn't going to work. You have to decide quickly. Everybody, we've all done this now a number of times. We've gone through a number of phases. You'll get good service wherever you go, as long as you get the decisions done quickly, and then you can move forward.
Yeah, I left Reg IM CSA negotiation challenges to my friend down the end there,
Yeah.
Doug.
So I would agree with everything that was said on the custodian side. The one thing that I'd pull back on a little is, yes, you have to move quickly, but you have to be strategic about it. Okay, and you have to make an informed decision, because I think there's a couple of things that are really important on the custodian side, because as far as I'm concerned, the choice of your custodian is the first external step you take with respect to Reg IM. Now, there are internal steps that happen before that, right? You have to basically do some learning, education internally. You need to get your team set up internally. You've got to figure out if you're going to run SIM or not internally, and so on. So there's all that stuff. The first external step for me is choosing your custodian, right? And I think, and I'm not just saying this because JPMorgan and Bank of New York are on the panel, but there are a couple strategic questions that I think are actually in their favor in many cases. One is, what kind of collateral do I want to post, right? Those guys, as they told you, they're the tri-party they're the bank tri-party custodian. So I think that collateral offering is probably broader than other bank custodians. The other thing that I think has been really, really interesting over the last phase, and will surely happen in Phase 6, is buy-side clients, right, non-dealers, are now more and more going to their dealer counterparts and saying, I do not want you to post to me at a central securities depository like Euroclear or Clearstream. And I do not want that because I cannot individually sign up and become a member of those CSDs. But I can be a receiver in my own right at JPM and Bank of New York. And please, guys, correct me if I have any of that wrong.
Well, you can use the representative model.
You can, but not directly. Well, actually, some very, very large buy-side entities that are the size of banks have become members of Euroclear, but it's not easy. So to make their lives easier, and I actually think this is a very strategic and smart step of the U.S. buy-side in particular, they've gone to their dealer counterparts and said, well, who's your bank custodian? Because that's where I want to receive, right? So that's very important. The other thing to think about, and people sometimes forget this, is you have to have a third-party custodian. So if you trade with, if a dealer is If Bank of New York is your number one trading counterparty, that should be taken into account when you consider whether or not you're going to use them as custodian. Same for JPM, same for State Street, same for Northern Trust, and everyone else, because you won't be able to use them in that instance. So I certainly think that decision needs to be made, and 100% needs to be made on this side of the new year. I would even be making it, and we're telling clients they should be making it this month. But please make it in an informed and strategic way, because it is going to dictate a lot of what the other things you do for Reg IM, including what documentation you put in place, right? So John said Reg IM CSA. Yeah, sure, you may use that, but that's only if you're going to use a custodian who's going to house your collateral in New York under New York law ACA. If you're doing it with Bank of New York or JPM in London, you're going to use an English law CSD. Right? If you're doing it in Belgium, you're going to use the bank custodian CTA and a security agreement under Belgian law. And that may have implications, right? If you're sitting at a shop or you're using even a third-party service provider, do they have the capability to cover you in each of those jurisdictions with each of those governing laws? And can you avoid it? Right? I know we're using avoid as like a dirty word, but it isn't a dirty word, right? We just want to do things as efficiently as possible. So I would say that you really need to kind of understand what you're getting yourselves into, and then you need to move at light speed. Is light speed required? Yes, but let's do it in a strategic way.
It's a good point. There's, as we're coming closer to time, maybe a hardball or question at everyone here, depending on how you take it. But being that we're now towards phase 6, and definitely we're going to learn towards phase 6, what do you think is going to start to become the steady state or best practice, or something that you would see going forward from all of the culmination of what we've learned? Do you think there's anything new that might come about in terms of best practices in the respective areas that you're most comfortable discussing? Maybe I could start this side, or I'm looking at Amy.
Get your documents digitized, use online negotiation tools, streamline your online negotiation data into your collateral management system, so then you can automate your margin call process and your settlement process and your reporting, and be as efficient as possible with portfolio reconciliation and dispute management. Now is not the time to use duct tape and bubble gum, because your volumes are going to go up. And if you have a volatile week, and whether we're working from home or we're not working from home, you still are going to have problems, especially when you get to situations of recalling collateral. That can be quite arduous if you're not automated. So that's the best practice, and we have a document for that on the Info Hub that outlines everything you need to be as efficient as possible. So that wasn't a hardball. Thank you. I thought it was a softball. Thank you very much.
Doug?
So if Amy says automation, I'm obviously going to say is to create. I can't resist mentioning is to create. So that's how I would suggest everyone negotiate their documents. But maybe I'll give you one other thing for people to think about, because I'm really interested to see how this all plays out, and that's separately managed accounts. So I am all for taking very complex problems and solving them. I'm not sure there's really a good solution for this very complex problem, which is why I want to, there's just an information asymmetry here, right?
And the end client is the one managing the documentation and passes it off to the asset manager. Sorry, I'm speaking from a former buy-side perspective and someone who had to do onboarding, not for UMR, but for other things. If the end client says, here's the ACA, here's the CSAs, take it, run with it, execute, trade, do what you need to do, this is your initial margin threshold, that may not be the best solution for a complex portfolio or legal entity, but it is the simplest way to approach September 1.
I would be all for simple. We'll see what happens.
So Doug, just to go on, do you not think that's simple, or?
The simple solutions aren't always the ones that are implemented.
Right.
In many cases, they're not, unfortunately.
Because it's not always the best option from a fiduciary responsibility.
Yes, and for many other reasons, it might not be. For fees and things, things that matter in the real world outside of Reg IM. So we'll see what happens. I'm interested, but I agree with Amy. I think that could be a solution.
Okay, Tara.
One thing I want to mention we haven't really touched on, and Doug said, the first thing you need to be doing externally is get your custodian. I would argue that before that, you have to disclose that you're in phase 6, right? So, and I get that you're not at the end of calculation period, formally, unless it's the USPR, but you have to make those estimates, right? You just have to and move forward if you believe there's even the remotest possibility you're going to be in scope for phase 6, and there's a chance that, you're going to need to exchange anytime near September 1st. You're going to need to let your counterparties know because that kicks off everything, right? Like that starts the communication channel to be able to engage externally, whether it's for, your CSAs or whether it's for your notifying and finding out about the custodians your dealers are using and notifying them of what you're using, et cetera. So do that self-disclosure if you haven't already. ISDA supports some different mechanisms to do that, but any way you get it accomplished is still helpful.
So step 1, best practice disclosure. Yeah. Okay. Ed?
Okay, thanks. Obviously, Seg IM's a two-way posting, right? So you're going to post, if you're the phase 6 firm, you're going to post your collateral to the dealer, your counterparties. They're going to post to you, right? They most likely, somebody said it, are going to post in tri-party. That doesn't mean you have to post in tri-party, right? You can post it any way you want, right? So I would, and this is kind of an anti-sales thing for tri-party, but it's a disclosure I want to make, right? If you are comfortable or know that you're going to maybe only post treasuries, right? And you're comfortable posting treasuries bilaterally, then the third-party solution is fine. And Ted rattled it off. Both of us have a third-party solution, a number of other custodians out there. Tri-party speaks for itself. If you have a big enough portfolio with a number of counterparties, I think tri-party is the best solution. It's automated. It's really going to take that operational burden off you and your counterparty. They're going to want to receive it in tri-party, but you don't have to go that route. These are the conversations you should be having soon with someone. And the last thing I want to say, today's November 16th. So that means tomorrow's January 15th. Right? So you haven't decided now and you're not about to pull the trigger this week. You're not doing it next week, right? You might do it the first week or 2 in December. That means you're not doing it until the second half of January. So it's already getting late.
So Ed and Ted will be taking calls over Thanksgiving.
Yeah.
Alongside their pie.
I think they're making me work the day after Thanksgiving. I'll be looking for something to do. So call me then if you're ready.
John?
What was the question again?
The question was moving forward, phase 6. But moving forward, what do you want to see as best practice coming out of all of this that we've learned in the last couple phases?
What I want to see as best practice, I think it's not going to. First of all, it's not going to end with phase 6, right? We talked about the tail and we talked about the numbers. And this is going to go on for quite a while. You're going to have to calculate your ANA every year and see where you land. You can come in, you can come out of the rules, et cetera. And I think we're all talking about the same thing. I think, I don't know if I've done a lot of these panels. Sometimes it comes off as like doom and gloom, like, oh, you got to do all this. That's the bad news. And maybe the bad news might be you're in scope for the rules. The good news is that everybody on this panel, in one way, shape, or form, whether it's ISDA with all their great free info, whether it's our tri-party agents and our third-party custodians and our legal counsel, we've been through this already a lot. There are so many solutions to aid in your UMR compliance journey. That's the really, really good news. There's a lot of standards that have been put together. Doug mentioned ISDA Create. I'll mention that we're the de facto standard for calculating IM and reconciling it, which is what you probably have to do if you're going to calculate SIM with a counterparty. But that to me that's the bright spot, and I want to kind of end on a positive note because there's experience, there's a lot of standards that have been set through ISDA and through the industry, and there's solutions that have been built around those standards that really there's really no excuse that you shouldn't have like a humongous challenge getting through it. Obviously, there's an investment to be made in that, but those are the choices you're going to have to make. I do think that that same theme of early is still relevant, and it will be going forward. I don't know if I answered your question, but that's my answer.
I think you did. Okay. You did. There's solutions out there, and use the solutions, right? Yeah. Positive. Ted?
And to build on that, I think the best practices have already been, you already said them all, right? It's Acadia Soft and automation, or centralized, standardized ways of calculating and communicating. it's automated releases, it's Create IQ. So I don't have to go. I just did to get one of them again. I don't have to go into those again. What I would say is the approach that I'm taking, we at BNY Mellon are taking, and I would encourage everybody to take the same approach. Is you look at everything you're going to have to do, whether it's high volume onboarding, whether it's document negotiation, whether it's exchanging collateral calls, and you say, okay, what is really just for applicable to now because of what we're going through, and then what are the challenges we're going to have after this? And so you find the challenges that are going to be after that, and you solve with automation and technology. So we decided to use Create IQ in large part because we're going to be challenged with all our ACAs, but also that's an important tool to have even after phase 6, because we're always going to be negotiating documents, and there's more ways we can leverage this, right? And we've always used Acadia software. We're always going to, because even after phase 6, there's going to be margin calls that have to be processed, and so you should have automation. But things like 3,000-4,000 accounts being open in the course of a month, we don't need to automate that. We'll figure out a way, through staffing up and consultants and all of that to get through that piece, because the solution we put in there, if we built a big automated industrial strength solution in there, would just be wasted after this, because we're never, knock on wood, we're never going to have to go through that kind of onboarding volume again. Yeah, I just ruined it. But so my point is, think about what will really serve you well after, and then take advantage of all the focus and budget that's going into this right now. Because if you don't do that, it's an opportunity missed. And then the things that really are just a point in time, you can figure out a tactical solution for that.
Well, thank you, panel. Any questions from the audience before maybe we reconvene outside? No? Well,
I just want to make one more point.
Ed?
I just wanted to pick up on something Doug said. I vowed that I wasn't going to say this, but I have to say it because of something Doug said earlier, and I made reference to it too. JPMorgan is arguably the largest derivatives trader out there. So ourselves as JPMorgan custodian, JPMorgan tri-party agent, obviously can't hold the affiliate related collateral, which was it has been an issue in phases 1 through 4. We actually built an automated solution for that in phase 5 so that we can handle 100% of the collateral. We just auto deliver out the affiliate related collateral to a third party. So I wouldn't have said it because I didn't want to do any commercials up here, but because it was said the other way, I just wanted, and no offense, Doug, but I just wanted to clarify that because it was something that we faced with pretty much every single client that we're dealing with or trading with JPMorgan, we had to build a solution for that. So apologies for the commercial, but I just wanted that information out there.
Technology is always great. We welcome it. Okay. Thanks to the panel, and thank you, and appreciate it, and hopefully we continue at the reception.
Thank you.
Thanks.